Good morning, all. We're so pleased you could join us this morning. We're just about to get started here. Maybe give about 30 seconds more to get folks in here, but we're so pleased that you have joined us. All right, as we're closing in on 11:04, I'll go ahead and get us started. So good morning and welcome to the first in a series of webinars being hosted by the Attorney General's Office. My name is John Green, and I'm Chief of the Nonprofit Organizations Public Charities Division here at the AGO. We know firsthand how broad and vibrant the nonprofit sector is here in Massachusetts, and how important you are to the people and communities you serve and to the economy of the Commonwealth. We're so glad you've joined us this morning for our initial webinar presentation in a series of webinars that is designed to provide guidance and assistance to the nonprofit sector. We know many of you have questions for us, and many have shared those questions when you registered for this webinar. We want you to know that we've incorporated many of those questions into our affirmative presentations today, and we'll address others in a moderated Q&A section later in this hour. I'll also have more to say about the Nonprofit and Charities Division at the end of our hour, including an introduction to our upcoming monthly webinars. Before that, you'll hear presentations from several of my colleagues at the Attorney General's Office about all of the important activities that our office has been engaged in, especially over the last 7 months. But first, at this time, it's my great pleasure to introduce Attorney General Campbell, who will kick us off.
Thank you, John. I'm assuming everyone can hear me, so just thank you very much. And of course, thank you to my incredible team for putting this together. And thank you to everyone who is in attendance. We know how busy you are, so we're grateful that you would take time out of your busy schedules to join us this morning. We know, and as John alluded to, that nonprofits serve a key and vital, not only a key role, but a vital support system for our Commonwealth and some of its most pressing needs, touching every aspect of our lives, from our economy to our culture, community development, education, healthcare, and so much more. Your organizations generate billions of dollars in revenue, employ a significant portion of our workforce, and care for our most vulnerable residents. You are the reason so many folks flock to Massachusetts for our world-class healthcare system, our educational systems, our life-saving medical research, and more. And in spaces where both the private and public sectors are leaving gaps, it is you who are stepping in to fill those gaps and serve our most vulnerable communities and those most in need. Over 4,000 participants from nonprofits all across the Commonwealth have registered for today's webinar, which is absolutely incredible, and we are grateful. As the federal administration has continued to illegally withdraw funding and wage attacks on initiatives that support our residents, from threats to DEIA to our immigrant and LGBTQ neighbors, we know that the nonprofit sector is being faced with new challenges, questions, and uncertainty. Over the past 8 months, your organizations have faced unprecedented changes, and that has impacted the way you have to approach your work. We've faced uncertainties, you face uncertainties, as we have as well, about whether or not you'll have enough funds to keep your organizations running. You're fearful about the safety and well-being of those you serve, as well as for your staff and maybe yourselves. You may be questioning how to continue practices that foster diversity, equity, inclusion, and accessibility in your organizations, and how to serve communities that have been targeted by the Trump administration. Indeed, your job is undoubtedly more difficult than it has ever been before. Yet still, in the face of these challenges, you have remained committed to serving our communities. And my office and I are truly grateful for everything that you have done and continue to do. That's why we've made it a priority to support you and to hold this administration accountable when they violate the law in ways that harm your organizations and your constituencies. Over the past several months, we have been closely monitoring the actions of the federal administration, whether that's unlawfully cutting crucial funding, slashing programs and agencies, weaponizing our civil rights laws, or persecuting institutions and individuals for their own political gain. And as a state chief law enforcement office, we've been using our unique authority and our unique tools to protect our state and our economy by both holding the administration accountable for legal actions and providing tools, resources, and guidance to our constituents. Naturally, the work we're doing extends to and impacts the work of nonprofits. We filed lawsuits to halt unlawful funding cuts and program terminations, and successfully secured court orders to stop those cuts. And in some cases, we've reinstated funding while lawsuits, of course, proceed. You may have heard last week, the Supreme Court issued a deeply disappointing decision in one of our NIH cases. You'll hear more about that later in the webinar. But even in instances where accountability is delayed and where the court, we think, gets it wrong, we won't stop fighting to protect funding, protect our residents, the rule of law, and of course, your institutions. Where nonprofits have stepped into the breach to defend themselves, we've also joined you. We filed amicus briefs and partnered on companion cases. As the administration has attempted to stoke fear and division through executive orders and policies that attack the rights and safety of those you serve, we've also released resources and guidance to affirm their rights and help folks navigate these challenges, especially those in our immigrant communities and LGBTQ communities. This includes guidance affirming the right to also implement DEI initiatives in our workplaces and educational institutions and more. We know that the administration's actions are impacting your organizations, your programs, and the communities you serve. Unsurprisingly, you have questions and hard decisions to make. And my team and I want to be here for you. We want to support you. We want to work in partnership with you because we know we cannot do this work without you. We remain a committed partner to nonprofits all across the Commonwealth, valuing what you bring to the incredible ecosystem we're blessed to have in the Commonwealth. And we're here to serve as a resource and sounding board to help you navigate these uncertain times. So this is why the team is launching this new webinar series to help you navigate the many challenges and uncertainties of this shifting nonprofit landscape. You will hear from this incredible, and I say my team is incredible, they truly are, but the incredible nonprofit organizations and public charities division of the office, led by John Green and Emily Gerbrault, and experts from other parts of the office on this webinar who will answer your tough questions and all the issues that you are facing and continue to be available to you after this webinar. You'll also hear more from John from our nonprofit division today, who you just, of course, heard from briefly, along with other members of the team about the resources that are available to you. And I and the team encourage you to look at our website, social media, you name it. We'll make sure you have that information to not only get these resources to your organizations, but to the constituents you serve. I also hope you'll join us each month as we continue this series. And of course, we want to be available to you. So also share with us what information will be helpful and useful to you as you navigate these uncertain times. But at the end of the day, I want you to be clear. I, along with this team, will operate with a sense of urgency, empathy, and compassion, recognizing what not only is happening now, but what is to come. And we are ready and we are prepared, and we will, and I will operate with no sense of fear because we know what's at stake. As you do the work, I encourage each and every one of you to take care of yourselves, take care of each other. Massachusetts is not that big. Organizations, of course, connect all the time. Our mental, physical, and spiritual well-being is equally important and must be sustained as we do the hard work that lies ahead. But collectively, we will overcome this administration and all that is to come, while also still doing the proactive work that our constituents demand of us. So thank you for being here this morning. I, along with the team, are incredibly grateful. And we, of course, look forward to working in partnership with each and every one of you. Thank you. I'm going to turn it back over to John, and team members will, of course, navigate the presentation for today. But John and Emily in particular, thank you and the entire division for everything you're doing, nonprofits and charities. Thank you.
Thank you, Attorney General Campbell, both for your time today and for your words and for all of the emphasis you've been able to put on to responding to the federal administration over the past 8 months. It has really made the difference in terms of stepping up for the people of Massachusetts. I would like to remind folks now, just as an administrative note, if you'd like, you could certainly turn on closed captioning if you are in need of assistance with hearing the speakers through closed captioning. Please do add the closed captioning through Zoom. At this point, I would like to turn to our first panelist. So I'm going to introduce our Chief State Trial Counsel, Catherine Dirks, who will provide us with an update on the work our office has been doing to hold the federal government accountable. Catherine? Catherine, I'm sorry, I can't hear you.
Can you hear me now?
I absolutely can. Thank you.
Excellent. Thank you, John, for your leadership here, and thank you, Attorney General Campbell, for your support and leadership as we work through these issues. Again, my name is Catherine Dirks, and my job as Chief State Trial Counsel is to coordinate our federal litigation response to the actions of the federal administration, among other things. What that means, or has meant in the last 7 months, is creativity and a lot of hard work to try to do as much as we can to support our residents, to support our communities, to support the organizations, both state and non-state, that we can as they deal with incredibly uncertain times. I want to acknowledge how difficult it has been for all of us, but especially for any organization that has dealt with the funding uncertainties that have come from the various actions of the federal administration. The state agencies and state institutions, our higher ed institutions, have been in the same position. It's been exceedingly difficult, and I acknowledge how difficult that's been for you as well. Our office has filed 32 lawsuits since the administration began on January 20th, challenging various actions of the administration. Of those, 18, at least 18, have been directly related to funding disruptions within the state. So it's more than half of the cases that we have filed. I'm going to go through the categories of cases so that you have a bit of an understanding of the landscape of the funding disruptions and our responses to them. But in all of them, the role of our office is to do as much as we possibly can to check executive overreach in its assertion of control over the power of the purse, something that belongs to Congress and something that reflects ultimately the democratic process through the election of representatives who then put together a budget, fund programs, and support various policy goals from the legislative branch. Our ability to push back against those disruptions is limited to some extent because the Massachusetts Attorney General's office does not always have standing to assert claims on behalf of non-state actors. So some of our cases you will see are explicitly or more explicitly on behalf of state institutions. In other cases, we have been able to seek and obtain relief that extends to non-state institutions as well. And I'll be able to give some examples of that further in my presentation. So where are we since January 20th? I want to go through what I have taken to calling the waves of federal funding disruption that we have seen, and to tick through it chronologically, even though those categories have had longer lifespans in some cases than in others. The first wave of funding disruption that we saw was what we call the OMB federal funding freeze. That happened on January 27th, when a directive was issued from the Office of Management and Budget, the OMB, stating that all federal funding to grant recipients, with very few and narrow exceptions, would be paused until OMB and federal agencies could review whether those federal funding disbursements or payments were consistent with the president's priorities. The states, with Massachusetts as one of the leads, filed a lawsuit the next day. We filed a complaint challenging this exertion of control over the federal budget. over federal disbursements as unconstitutional and in violation of federal statutes that place constraints on what federal agencies can do, both procedurally and substantively. We obtained immediate relief in federal court on that piece with a temporary restraining order followed by a preliminary injunction. And that case has proceeded up to appeal and is currently pending in the First Circuit. The second wave that we saw were indirect cost rates controls. Indirect cost rates are a financial accounting tool that are used to reimburse institutions for their structural and administrative costs that are associated with various federally funded projects. So we've seen this in the NIH case, which involves research that has research projects that have a very high level of infrastructure costs. And those infrastructure costs or administrative costs are all funded through indirect cost rates. The federal administration has attempted to exert caps on those reimbursement rates in various ways, from NIH to the National Science Foundation, NSF, to the Department of Energy. There is a hostility to that type of reimbursement for various reasons, and we have filed lawsuits challenging those caps. The third wave of funding disruptions that we saw were grant terminations. And those have continued, unfortunately. And I know that a lot of your organizations have been directly impacted by that. The grant terminations that we've seen have both been large scale, entire grant terminations falling within entire federal programs. In some cases, they've been more discretionary and case by case as the administration has reviewed particular grant programs for whether those particular programs are deemed consistent with the president's political priorities. The fourth wave we've seen are grant conditions. So these are conditions placed on existing grants, grant conditions that did not exist and were not imposed at the time the grant was awarded. But we have also seen conditions placed on grant application terms. So notices of funding opportunity that are made available by the federal government are now containing, at times, conditions that are unrelated to the grant program that is being subject to award, and unrelated really to the mission of the federal agency that is awarding the grant. And we have filed lawsuits challenging those grant conditions when they are counter to federal law. A fifth category, the fifth wave, has been entire program terminations. So this might include programs with awarded grants, but also funding streams for which the grants have not been awarded. So examples of those include the FEMA BRIC program, which supports many of our municipalities and works with a lot of our organizations throughout the state to make our communities more resilient to climate change and natural disasters. We're also aware of termination of the Solar for All program, which is also a program-wide termination. So as you can see through those 5 waves of federal funding disruptions, which I'm sure will continue to evolve, we have dealt with a very dynamic situation and a very challenging legal landscape, a challenging financial landscape, which of course has made it very difficult for our state agencies and state institutions, and of course all of yours, to engage in planning and to have the same reliance on predictability in federal funding streams that we've had for decades up to now. I promised you an example of a case where we have been able to obtain some relief that extends to our nonprofit partners and allies, and that is the AmeriCorps case, which many of you may be familiar with. As many of you know, the administration announced an end to AmeriCorps this spring, and the states, including Massachusetts, filed a complaint at the end of April, challenging both the dismantling of the AmeriCorps, but also the termination of grants to our state agencies or to our associations that are ultimately responsible in the state for administering AmeriCorps funds to nonprofits throughout our states. Massachusetts has been involved in that case from the beginning. We've obtained preliminary injunctive relief. And then we saw yet another attempt at funding disruptions from the federal administration. In the litigation, we learned from AmeriCorps that while AmeriCorps was standing at the ready to comply with the court order's preliminary injunction, the funds had not been made available to AmeriCorps. And we learned that the Office of Management and Budget, OMB, had withheld the funds from AmeriCorps, such that AmeriCorps could not, in fact, disperse the funds to grant recipients consistent with the district court's preliminary injunction order. So what did the states do? We amended our complaint and we named OMB as a defendant as well. And we filed a second motion for a preliminary injunction to ensure that OMB would be encompassed within the scope of equitable relief that we had already obtained. That case is proceeding. It has not yet been appealed, but it's one of the mechanisms we have tried to use to obtain relief for our states and for the organizations that are doing all of this important work. In the interest of time, I'll stop there, but I'll almost stop there, but make two quick notes. One, the Attorney General referenced the decision we got in our NIH grants termination case on Friday from the Supreme Court. I'll give you the quick summary of what that case did. It came out in our favor in one aspect. It found that the federal district court had jurisdiction over our Administrative Procedure Act claims that challenged the legality of NIH's directives. Those directives essentially instructed all NIH staff that funding in various politically disfavored categories could be withheld, should be withheld, must immediately be withheld. And those directives remain vacated as a result of the district court judgment, which the Supreme Court did not interfere with. But the Supreme Court did vacate the judgment that had provided us relief on specific grant terminations, that had vacated those terminations. And the court, with Justice Barrett as basically the deciding vote, found that the district court likely lacked jurisdiction over those claims, and those claims should have instead been brought in the Court of Federal Claims. This is a new decision. We're obviously still reviewing, but more to come in this space as the various funding cases deal with the implications of that decision, and you'll see procedural next steps follow. My very last point are to provide you some points of contact for issues that may arise for your organizations that pertain to our active litigation. Our nonprofit and charities division is standing at the ready to act as that point of contact. And I see John Green is back on the screen. So John is our fearless chief of that division, and he can help put you in touch with the right people as you deal with these issues going forward. Obviously, there's limits to what our office can do because we don't provide direct representation for you. But we stand at your side in helping to navigate these next steps.
Thank you so much. Thank you so much, Catherine. We really appreciate your perspective on this and all of the work that you have been shepherding over the past 8 months. And if it's okay with you, we'll come back to you during a Q&A section a little bit later to maybe touch on a couple of things. We really appreciate that. Just wanted to touch on a couple of things. One that we will, during the affirmative presentation on the charities division, we will certainly go through some materials about how to get in touch with us. We'll provide you with a link that you can use to get in touch with us. There's many ways to get in touch with us, depending on what it is that you'd like to reach out to us on. Also wanted to touch very briefly on a couple of administrative notes. One is to just expand on my note earlier about closed captioning. If you do wish to turn on closed captioning, you certainly can. It looks like for most folks, if you click on closed captioning in the bottom bar, or as it is with me, if you click on more, you'll get an option to click on closed captioning, and that would turn closed captioning on for you. I also wanted to note that we are recording today's session, and we will be making a recording of that session, I believe, with the closed captioning turned on. It may take us a bit of time to get that prepped and ready, but when it is ready, it will live on the new resources page that the Charities Division has put together, and which I'll be talking about a little bit later in this hour. So Without further ado, it's my pleasure to introduce Angela Clark, who is Chief of Organizational Diversity, Equity, and Inclusion Office here at the AGO. Angela.
Yes, thank you, John. First, again, I'm Angela Clark, pronoun she, her, and hers. And as John mentioned, I'm the Chief of Diversity, Equity, and Inclusion for the Attorney General's Office. I want to start just by thanking all of you for joining this timely conversation around the impacts to nonprofits in Massachusetts. I want to start by providing some clarity around diversity, equity, inclusion, and accessibility. First, engaging in DEIA work does not violate 501c3 requirements. In fact, it often prevents organizations from being sued or investigated for not creating inclusivity for everyone. Nonprofits are absolutely allowed and should advocate for equity. You are allowed to uplift marginalized voices in communities in which you serve. You are allowed to address systemic barriers as part of your mission. Even under current scrutiny, diversity, equity, inclusion, and accessibility is not inherently political. DEIA focuses on creating fairness. It's about opportunities. And by that, I mean it's about opportunities beyond just the top 1% to 2% of our population. It goes well beyond the focus of race and gender, and obviously it impacts all of us. Over the past several months, as AG Campbell mentioned in her opening remarks, the office has created educational resources to ensure that all of you stay informed. And all of these resources that I'm describing to you will be provided at the end of the webinar. So if you're able, please keep your phone out to scan the QR codes. Education in knowing the law and your rights as citizens of Massachusetts is the most effective strategy to combat the current federal administration's unwarranted attacks on our democracy. In February of this year, the Attorney General's office created guidance to help businesses, nonprofits, and other organizations understand the continued viability and important role of diversity, equity, inclusion, and accessibility efforts. This specific guidance provided clarity around the business case for DEIA. It addressed the bully tactics of the current federal administration head-on, and it provided concrete actions that nonprofits should be focused on with respect to diversity, equity, inclusion, and accessibility. Policies incorporating DEIA best practices are not just compliant with state and federal civil rights laws, but as importantly, they help reduce the litigation risk, as I mentioned. On March 5th, the Attorney General's office team issued guidance focused on institutions of higher education and K-12 schools with a very similar message. It addressed the 2023 decision around race-based admission in higher education institutions. It sought to clarify the legal landscape for institutions in Massachusetts, as well as clear up any misconceptions or confusion per the current administration's ongoing executive orders and constant communications beating down the education institutions for caring for their students, all of their students. In May of this year, the Attorney General's office team put out Know Your Rights guidance for immigrants, for families, and communities of ICE enforcement to make sure these communities know their legal rights and basic legal framework for U.S. immigration and custom enforcement actions. Thus far, the feedback of the guidance has been overwhelmingly positive. Constituents and organizations and nonprofits have found this targeted approach to be helpful in clarifying any confusion that may have been transpired as a result of the fast pace of some of the rhetoric being communicated by the current administration. The reason I share all of this is to ensure that all of you have information around your legal rights and support from our office around diversity, equity, inclusion, and accessibility, and obviously beyond. All that said, I also want to make sure that I acknowledge the very real fear that many of you as nonprofit practitioners feel in this very moment. The threats, whether they are perceived or real, of losing federal funding, having your 501c3 status questioned, having to make decisions around terminology to stay afloat, is something not to take lightly. But I will also say it is extremely important not to let the fear drive you away from your core mission. We'll talk more about this when we get to the Q&A piece, but I'd like to end with, I'm extremely grateful to be part of this conversation with you today, and I appreciate all of your participation. So with that said, I will turn it back to John.
Angela, thank you so much for your leadership in this area and for your words today. Really appreciate it.
Thank you.
And we hope you will stick around too for our Q&A later. It's now my pleasure to introduce Elizabeth Matos, who is Chief of the Civil Rights Division here at the AG's office. Happy to let Liz take this away.
Good morning, everyone. Thank you so much for being here with us today. I am Chief of our Civil Rights Division and will be talking a little bit today about the various guidance documents that we've issued, particularly in the immigration space, and that are relevant to many nonprofit organizations, including general service providers. So we have issued a number of documents, and all of these documents are available on our immigrant resources page, and specifically have been a number of the documents, almost all of them that are posted there have been translated into a number of other languages. So you can find that if you look up MAAGO, Immigrant Resources, you can find the documents there. But I will name a few now and go through some threads that are common to all the different spaces and touch on as much as I can in the very short period of time, and just encourage you to look at the documents when you have time, which provide much more detail. So we have released ICE enforcement guidance in the education space, which are relevant to K through 12 schools, as well as institutions of higher education and early childhood education. We've also done ICE enforcement guidance for healthcare providers and for service providers and employers, and have issued guidance on engagement with ICE. I won't be covering much of that today, but please look that up as well. And that is really about engaging with ICE in our communities and on the streets, and is relevant to bystanders as well, and kind of covers what the rules of engagement are in rights that you have if you are engaging with ICE, and including rights that bystanders have, and also some things to be aware of in those interactions. In addition, we have put out an emergency family and children planning guide for people with uncertain immigration status that really covers some legal options and what to do to prepare for the future in the event that a parent or guardian is detained. So that is also a good document to get to more detail, and I'll cover some highlights again from a number of these. So first, it is really important, if you haven't done this already, to train and prepare your staff. Hold Know Your Rights trainings for your staff. You can also hold them for folks that you're providing services to. Distribute rights cards. Consult guidance from other organizations and agencies. Of course, we'd love for you to look at ours, with Office of Refugees and Immigrants, the Mirror Coalition, National Immigration Law Center are just a few that have put out a lot of resources that are relevant to folks in this space as well. So I would encourage you to check those out. And if you haven't done this, designate a staff member as the responsible person for interactions with ICE or other law enforcement that approach your institution. And this really helps with making sure that that particular person, or if you have a backup person, that they are fully trained and understand how to engage with the law enforcement officer. So for example, if ICE does approach your institution, or any other law enforcement officer, you can have sort of a script prepared that you're not attempting to obstruct their actions. You're not authorized to respond, though, to their requests until you contact the appropriate person who is the authorized person. So that is one piece of the training that we recommend. And then that person is the person who is designated is more equipped to then look at any paperwork that the law enforcement official may have around a judicial warrant or administrative warrant, and whether or not they actually have the authority to be requesting information or entry into your facility. You can also designate private areas within your organization or facility that are close to the public. You can use signage, you can have key cards or locks to promote a safe environment conducive to the organization's mission. Law enforcement agencies, including ICE, cannot actually gain access to designated private areas without the organization's consent or, of course, a judicial warrant or court order. So it's important to really clearly designate those spaces if you are going that route. And then, of course, if you have the ability to do this, to have legal counsel that you can reach out to review any documents with designated staff members to ensure that they are, in fact, legit and appropriate. And another important thing to do is if you do have private areas, you want to ask the officer to wait outside until you contact legal counsel or the designated staff person. Okay, so a couple of things, since we are quickly approaching back to school, pretty much feels like we're in that mode already. I wanted to mention a few things in the K through 12 space. Schools must enroll students and provide equal access to education regardless of immigration status. There's a lot of guidance on this out there, specifically from DESE and others in the state. So please, you can look at their resources as well. But schools should be revising enrollment policies to collect only the information necessary to verify a child's age and residence. Districts should also not be collecting documents containing passport, visa, social security information, and should accept a range of documents, but not limited to just government issued IDs, including affidavits to really indicate that the child's date of birth is what it needs to be, and that all the information that you actually need is there. And it's also important to just highlight that student information is protected by both federal and state law, and schools cannot disclose to ICE agents the student's personally identifiable information without the parent or guardian's informed consent, or of course without a judicial warrant or court order or subpoena. And that information is also something that schools often have control over, includes a student's name, the name of the student's parent or family members. Sometimes it includes address and the student's social security number, date of birth, or place of birth. But again, we invite schools to really consider revising policies to restrict information where possible that would be accessible in those circumstances. For institutions of higher education, I just want to also highlight a couple of things. It is still legal, both federally and by state law, for undocumented students to be enrolled in institutions of higher education in Massachusetts. There are no restrictions on that whatsoever, but it is really important for institutions of higher education to provide clear and accurate information to immigrant students about admission, enrollment, and available resources, especially right now. And of course, so a lot of activity around student visas over the last year. So that is even more important as ICE enforcement activities, of course, have not subsided. A few other things for higher ed folks to consider is developing protocols, if you haven't done so already, of what to do if immigration officers request access to a space on campus or seek to interview or take custody of a member of the campus community, to proactively inform their communities that immigration officers may be present on campus for reasons that are unrelated to detention or deportation. They have an obligation to come and verify information, and they may not be there for those purposes. So that's also important to note, and to review the information that they collect from students to ensure, again, that they're not collecting information that you don't need. And this really pertains, I would say, to other service providers as well and employers. So please be wary of the information that you're asking for, especially in forms, to make sure that you're only asking for what you absolutely need in terms of, personal identifiable information. For healthcare providers, wanted to highlight a few things here as well. Again, protected health information is protected by federal and state privacy laws. Healthcare providers may not provide this information to law enforcement officials except under certain limited circumstances, similar to those that I've mentioned in other contexts. Providers are also not required to ask about immigration or citizenship status and may treat anyone regardless of immigration or citizenship status. So that has not changed. There's also, although there's a lot going on in this space, it is still legal and does not impact an individual's immigration status to utilize Medicaid, Mass Health, Children's Health Insurance Program, SNAP, et cetera. These programs are still programs that are not impacted by what's called the federal charge rule that would potentially harm someone's ability to adjust their status in the future. And then that is similar to, just want to underscore, for service providers that provide other kinds of services to the immigrant population, that those services, if they're not specific to very specific cash benefits, they're not implicated by the public charge rule, and people should not fear getting services from your organizations for that reason. And also the public charge test does not apply to green card renewals, those seeking immigration status as refugees, asylees, TPS, UNT visa holders, special immigrant juveniles, and self-petitioners through VAWA, which is the Violence Against Women Act. So really important to just highlight that as well. And there's a ton of information and it can be very confusing. So really invite you to look at our resources in the detention space. Just want to highlight one thing, as many of you may be getting requests for or ask for help to find lawyers. There are legal assistance organizations that can provide representation in the immigration matters, but it's really important to verify that they're actually equipped to do that. There has been an increase in the unauthorized provision of immigration law where people who are not actually authorized to provide those services are doing so, and that can be very harmful for people trying to obtain immigration status. And you can see if someone is actually equipped to do that either through there's an EOIR page online, which you can access through our service provider guidance. Or you can also see if someone's a legitimate lawyer by looking them up with the Board of Bar Overseers. Okay, just a couple of things to note for our emergency planning for families. So there are a few options that families have who have uncertain immigration status and are in the unfortunate situation, although we really encourage families to be talking about what to do in terms of future planning with their families, with their children, and with others. So they do have legal options. There's caregiver authorization. There's temporary agent authorization and guardianship of a minor. These are all options that parents have to think about and look at in the event that they are detained and their children are without a guardian or a parent. We are seeing people ending up in foster care as a result of detentions of parents. So this is an important resource to look at. Okay, very quickly, I just want to mention in terms of work authorization for certain immigrant populations that this is very much in flux. There's a lot of litigation happening around in the TPS space in particular, and for people on certain kinds of humanitarian parole, particularly Haitians, Nicaraguans, Cubans, and Venezuelans. And so we really urge employers to be careful about, terminating people on the assumption that they are no longer have viable work authorization because they may. And so you should really consult legal counsel and also check the status of that litigation online to make sure you are not unnecessarily terminating someone from much needed employment. Okay. I'm going to turn it back over to John Green, and thank you all so much for listening and for tuning in today.
Thank you so much for all of those very important points. We will be offering links through our resources page to many of the documents that were discussed. So certainly you can use those links to get there, but thank you for walking through those now. We really appreciate that. At this point, we are going to turn to our Q&A. So before I turn to that brief introduction to the Charities Division, we thought it would make sense to address a number of the questions that we've received from you through our registration process with our panelists. So these are questions that reflect what so many of you have asked us. And as we noted at the top of the hour, we try to incorporate answers to the most common questions into our affirmative presentations. But now we're going to turn to some additional questions, and I'll be looking to my colleagues to assist with those. So on the first, I'll turn to Angela. So Angela, how can we best balance our commitment to DEIA while also not jeopardizing our funding? That's something we've heard from a lot of organizations.
Can you hear me?
Yes.
Okay, perfect. I think there's a couple of things. One, I'll start with saying, engaging in diversity, equity, inclusion work, which I just mentioned, is well within your rights. You should continue to focus on it, right? Which helps to address the systemic barriers. We all should be focusing on this. Advocating for racial justice and equity is huge. Providing services targeted at addressing systemic barriers is a big deal. Creating internal policies to support DEIA is all work that we should be doing. But we also know that there is some fear out there in terms of, will we continue to receive funding? I think that was probably a third of the questions that actually came in. And so to answer that, here are some suggestions. One is consider diversifying your funding sources if at all possible. I'm not suggesting this is always possible, but when you can, I would ask that you think about diversifying where you spend your money. And so, for example, looking at potential sources in addition to federal grants is always helpful. I think about local and/or private foundations and other local and state grants that might be helpful. The second thing I would say is building coalitions with other nonprofits to amplify voices might also be something to start thinking about. The third piece is, and I know this is probably some of the work you're already doing. The third thing that comes to mind is building coalitions with other nonprofit organizations so that you have someone else to talk to and getting feedback about some of the things that they're doing and it's actually working. And then the fourth thing I would just say is to be really strategic in your federal grant language. You should not expect, obviously, to receive new federal grants if it's specifically focusing on diversity, equity, inclusion, and accessibility work, right? We know that. But I would also say there are definitely ways to use other resources to continue to do this work. And so an example that comes to mind, and then John, I'll turn it back over to you. If you're applying for a federal grant to train teachers, it might not be the right moment to highlight the fact that you are specifically focusing on diverse teacher recruitments as part of the goal. Instead, you can still uphold your values by committing to training all teachers effectively, which allows you to integrate inclusive practices without making diversity, equity, inclusion, accessibility your focal point. I hope that was helpful.
Thank you. That's very helpful.
Sure.
I'm going to aim my next question at Liz. What should nonprofit leaders know about interactions with ICE at their facilities or events? What can we do, they ask, to keep participants safe?
That's a great question and definitely highlighted in our documents. I think in addition to some of what I said about making sure you designate someone who is really trained and training all staff really on what to do. Some very basic things are to designate the private areas, which we talked about, but also to understand the difference between an administrative warrant and a judicial warrant, and to let the community that you're providing services to also know what your protocols are to the extent that you can do that. I think it does, although it sounds um, unsubstantial, I think it does help people feel a little less anxiety and to know that there is a plan in place and that you have protocols about engaging with ICE. Because I think people do think about that, right? They make their decisions on whether or not to go and access your services based on what the potential is for what the risk may be of them having an ICE encounter, and to know that you have a protocol and that there's something called a private space where they would not be able to gain access without a judicial warrant, I think is something that can be very helpful for your provider population to know. In addition, I would say to really stay up on the guidance documents, that things are sometimes changing in this space, and to continue to do the Know Your Rights trainings and distribute the rights cards. I think having as much information as possible is necessary. Nobody wants to think that they're going to be targeted um, or have, ICE at their doorstep, but we don't know. And rather than wait for that to happen, I think it's really important to be prepared.
Thank you so much for that. Catherine, I know another question that we got, and there's a couple of questions baked into this. Should we start cutting programs and resources now, or is funding for certain types of nonprofits more likely to get cut than others?
Yeah, it's such a difficult issue. In terms of funding that's impacted by litigation, one thing to keep in mind is that any court orders that have issued, for example, an order on a preliminary injunction, remain in effect until they're stayed, paused, or vacated by an appellate court. But those orders do apply only to the funding streams and federal programs at issue in those cases. So we don't really have court orders that provide broad relief across all aspects of federal funding streams. In terms of planning going forward, there's no denying that the federal disruptions of the past 7 months have undermined our confidence, as I mentioned before, in the continuity of federal funding, and that all recipients of federal funding are facing the same planning and budgeting challenges going forward that I'm sure many of you all are. In terms of the types of funding disruptions we might expect, or that might be more likely, more vulnerable to getting cut than others, it's been very difficult to predict. Given how broadly the funding disruptions, the funding cuts have been applied, and the variety of contexts in which they have arisen. We have seen certain patterns, for instance, programs that benefit socioeconomically disadvantaged groups, programs that involve environmental justice, programs that support immigrant communities have been more vulnerable. But we've also seen some cuts in areas that we would not have expected. For instance, the AmeriCorps programs are politically popular. They're a cross-cutting set of programs that benefit a wide variety of our populations, but those, as we saw, were vulnerable to cuts as well.
Thank you for that perspective. Panelists for their thoughts here. We really appreciate that. At this time, with the time we have left, we'd like to provide you with some information about the Nonprofit Organizations Public Charities Division, just to give you a sense of the areas in which we work and to let you know how we can be of help to you in the nonprofit sector. I'm also going to touch on the new resources page that we've created. And finally, I'll walk through the topic areas for the next 3 monthly webinars, all of which are scheduled for this fall. As the Attorney General Campbell noted earlier, our division is headed by myself and by Deputy Chief Emily Gibralt, who's been with us today. You'll be hearing from both of us over the course of the webinar series, as Emily and I will alternate hosting responsibilities. We oversee a dedicated team of legal and compliance professionals reflecting our dual role. While our attorneys work with charitable organizations on a variety of legal issues, our compliance team handles all registrations and annual financial filings. Attorney General authority over charitable assets is one of the oldest functions of an Attorney General's office, and this division has a long history of working with the charitable sector in Massachusetts and in helping to ensure its continued health and vitality. The moment we find ourselves in now is unlike any before it, and it's requiring you and your organizations to make difficult decisions and to perhaps even rethink the way that you work to fulfill your missions. We work with so many different kinds of organizations at so many different levels. And going forward, we hope to hear from many of you about the challenges that you are facing and how we can be of help. Please remember that we aim primarily to be a significant resource to you, and it's our goal to help you continue your work supporting communities across the Commonwealth. To that end, we encourage you to reach out to us by email, through our phone hotline, and through complaint intakes. And if you have any questions, please do. As we move forward, as you take a look at, get ready to sign up for additional webinars, please do continue to send us questions through the webinar signups. That's one of the ways that we will aggregate questions that we can use to help inform our presentations and which we can use for our Q&A. I do want to turn briefly to our resources page, and I know we're going to have a QR code come up for that resources page. One of our goals for this page was to assemble both introductory and guidance documents in one place to enable you to easily find them. And that's going to include a lot of things from the Charities Division, including our guide for board members of charitable organizations. In addition, we have our new Introduction to Charitable Compliance, which we refer to as a welcome packet. Additionally, we have a lot of other guidance documents, which you may be familiar with. You may have seen them elsewhere on our charities' web pages, but they're certainly available here as well. We also have used that resources page to gather other guidance from the Attorney General's office, some of which you heard about from our panelists earlier, including guidance about immigration issues and ICE enforcement, and about DEIA issues. We've also included helpful links to outside organizations that are focused on issues of importance to the sector, both at the state level and at the national level. And now if you'll bear with me for a couple of minutes, I'll talk just very briefly about the upcoming webinars. As we forecasted, today is just the beginning in a series of webinars. We'll be presenting them monthly throughout the fall, with the first 3 already scheduled. By going to the top of the new resources page, and we'll be sharing that QR code, you'll be able to see both the topics for the upcoming webinars and to register using the Zoom links that are already available there. All of those webinars will be held at 11 a.m., so we hope they will be convenient for you to attend. Up next, the second webinar in the series is scheduled for Thursday, September 25th, and we're calling it Organizational Restructuring, Strategic Affiliations, or Wind Down. As you all know, there can be times when, in fulfilling their fiduciary duties to the charitable organization they lead, the board and managers will need to consider whether it would be in the best interest of the organization and its mission to engage in a significant transaction or transformation. That could be a merger with another charitable organization, an affiliation with another organization doing similar work, a joint venture, or it might involve a more existential change, like a closure. The division has expertise in all of these areas and will plan to address a variety of them in the September webinar. The third webinar is scheduled for Tuesday, October 21st, and we're calling it Restricted Funds, Endowments, and Fund Modifications. Some organizations will hold different types of restricted funds, funds given by donors with restrictions on how they can be spent. Some will be endowment funds intended to be held in perpetuity with only expenditure of the income permitted. Others, often scholarship type funds, will have donor restrictions about how and for whom the funds can be spent. We will take the time to walk through these types of funds and can provide some additional insight about the role that the Attorney General's office, and potentially also the court, plays in modifying some of these funds because of changed circumstances. The fourth webinar is scheduled for Tuesday, November 18th, and we're calling it Advice for Smaller Volunteer-Led Organizations. Although we know that some larger organizations will have in-house legal staff or the budget to hire outside counsel, we also know that many organizations don't have those resources. This webinar will focus on guidance for these smaller organizations, but please don't be fooled by that title. All of the presentations we will offer should have broad appeal again across many different types and sizes of charitable organizations, and we invite all to attend. So please register for those webinars. Again, the links to those can be found on our new resources page, and please do submit your questions as part of the registration process. And now we've reached the conclusion of our program. We'd like to thank Attorney General Campbell for kicking us off today, and we'd like to thank all of our panelists for their time and expertise about so many important topics. Thank you all for joining us today. We look forward to hosting you again in this webinar series. And thank you to the team behind the scenes who helped put this webinar together and to make sure it ran smoothly. We hope to see you again on September 25th. Thanks very much.